From the News Channel 5 Network, this is MorningLine with Nick Barris.
Good morning, everyone. Thanks for joining us on Morning Line. I am Nick Barris. This is the big show, and it is Tuesday. No, it's not Tuesday. It's Wednesday. Don't want to fall behind. It's a short week for us all. But yeah, as Leland says, it is hump day. And Wednesday, we're going to follow up on a conversation we kind of got into yesterday. We did open phones. Turned out the vast majority of the show yesterday was spent talking about, these mass shootings that we've seen of late. Questions about gun rights and questions about whether or not there will be some type of gun legislation. Also questions about dealing with the growing problem of mental illness and the importance of security in places like schools, like churches, like businesses, and how to prepare for, God forbid, an active shooter coming into one of those establishments. But what we thought we would do as we get into the legalities of all this is kind of explore the Second Amendment a bit, go over what the Second Amendment specifies and how it is being interpreted and how it may change with what we're dealing with these days. And for that, I'm going to want to hear from you. We've got the number. We'll put it up on the screen for you. There it is, 737-7587. Questions, if you'd like to weigh in as we get into it, with our guest this morning, constitutional historian, professor at MTSU, John Weil. Good morning to you, Professor.
Good morning.
It is good to have you on, and I think this is a good show to have in the wake of what we've seen, especially most recently with the horrible shooting at the school in Texas. A lot of people questioning, all right, how far do gun rights go? What should be allowed? I think of late in many states, including here in Tennessee, we see the right to bear arms and your ability to do so expanded. Fewer restrictions, more access to people who want to hopefully responsibly own weapons. So I thought we'd get into with you the Second Amendment. I'll just start by saying, the basic text of the Second Amendment that many people refer to, and I know you have it in front of you, but you're familiar with this. It reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. There's more, but that essentially in a nutshell. That was written how long ago, John?
Well, it was adopted in 1791. It was part of the first 10 amendments, which are generally referred to as the Bill of Rights.
Okay, so my point, of course, that was a long time ago. What's amazing about our forefathers and the writers of the Constitution, so much of what they wrote all those many years ago still applies today. I mean, they were incredible in the way it was written. What do you imagine they would think looking at gun rights and the weapons we have today and how it applies to what they wrote back then?
That's a great question. I'm not sure. I know this. I know that one of the primary impetuses for the Second Amendment was the fear, particularly among anti-federalists who initially opposed the ratification of the Constitution. It was a fear of standing armies. They were very concerned that if you had a professional military, particularly within the country, that it might be used by authorities to, crack down on others. And so you had this little phrase at the beginning, a well-regulated militia being necessary to the security of a free state. Many of them were hoping that we would have a relatively small professional military, and then we would have something more equivalent to our National Guard as sort of the way maybe you would not quite the same, but how you would describe a militia. And for many years, there was a case, for example, in 1939, U.S. versus Miller, which seemed to emphasize that sort of prefatory phrase that the right to bear arms primarily referred to people who were in the militia or the National Guard or, state equivalent of that. In 2008, the U.S. Supreme Court decided in District of Columbia versus Heller that the right to bear arms was actually a more personal right, had as much to do with self-defense as it did with state or national defense. And that decision was subsequently expanded in McDonald versus Chicago 2 years later in 2010, which Heller had applied only to federal jurisdiction, and McDonald applied to state jurisdictions. So since that time, you could say in some ways that the Second Amendment may be broader than it was when it was first adopted.
So it has evolved then, certainly, from where you're thinking of militia to the point where it's interpreted. And again, it's interpreted by the populace of the time and the judicial system, right? I mean, it has evolved,
yes.
But I mean, at no point did any of the forefathers, when they write this, it was more broadly based. The right to bear arms, they weren't specific on what type of arms. We know even with the Second Amendment in place, there are certain weapons that yes. Americans cannot possess legally, right? So there have always been, to a degree, limitations.
You can't drive a tank down the street.
Right.
Yeah.
So, but it seems like, depending, I mean, the time could come where you say, well, we're going to allow you to have a tank. We read that as arms, and it's just across the board. It seems like it's certainly evolved.
It has, and of course, a lot of it has been technological advancement. When you have a rifle that you have to, load and reload every time you fire, that's a much different situation than if you have an automatic, weapon, an AR-15. That being said, it's not always easy to draw the line, as to when you have laws and you have to define what an automatic weapon is. But certainly, the framers would have been shocked, I guess, to find out, how many rounds one could get off in a matter of a few seconds, as opposed to the kind of weapons that they would have been familiar with.
All right, so now in the wake of this most recent tragic shooting, and certainly over Memorial Day weekend, there were several shootings, but of course the largest was of late the one in Texas. We see lawmakers discussing, okay, what types of legislation can be passed. We're looking at a lot of different levels, though, security at facilities, as well as
yes.
mental illness, as well as they're addressing the issue of, should there be some restrictions? It's safe to say in this country, okay, we'll never see the day where all guns are banned, and it's not, and very few, if anyone, really would advocate for that, but that there is a discussion of maybe placing some limits on certain types of weapons. How does that square with the Second Amendment when you do place regulations? As you just said, you can't have a tank. I guess, unless you have a special license, I guess you can't have a bazooka. Things like that are allowed. How will it square as lawmakers put forward? I mean, can a citizen say, wait a second, you can't pass a law like that. The Constitution says I have a right to bear arms, and it's not specific what type of arms. So I take that to be any kind of arm at all out there.
Well, I guess as a general rule, one might say that the only right that you could say in the Constitution that's an absolute, and it's stated more indirectly than directly, is you have the right to think what you want. We have almost complete freedom of speech, but you can't falsely shout, fire in a crowded theater just, because you enjoy seeing people panic. So most in Fourth Amendment, you can't have unreasonable searches and seizures, but there are times when, for example, police officers are chasing, someone who's just robbed a bank carrying a weapon, that one doesn't need to stop and get a search warrant to follow him into a building. So the question becomes what's reasonable and what isn't reasonable. One of the frustrating things I think about guns is, maybe the emphasis ought to be less on restricting guns than it ought to be on gun safety, phrasing it in those terms. Some of the regulations that have been considered, the so-called red flag law, where, someone has been identified with mental illness and is posing a threat to him or herself or others. I think there's renewed questioning as to, whether an 18-year-old should be able to get a gun, or maybe what kind of gun they should have access to. Maybe it would be appropriate to, let them buy a handgun in a way that it would not be appropriate to let them buy an AR-15.
Right, and the way to go about doing things like this can be through legislation. There has been some talk, which I think, there is absolutely zero chance of. We talk about how slim the chances are, at least right now, of passing any meaningful legislation with regard to gun regulation. Some have said, well, what about amending the Second Amendment? Now, amending the Constitution under any circumstance, is that realistic?
Well, it's very difficult, obviously, to adopt an amendment, but it is interesting that John Paul Stevens, who is, of course, a retired Supreme Court justice, actually wrote a book calling for 6 amendments, and mostly they were amendments to overturn decisions of the Supreme Court that he had disagreed with. But one that he suggested overturning was, in fact, the Second Amendment. I think it's probably more reasonable to say that, what we need to do is figure out, how to interpret the Second Amendment in a way that the Constitution does not become what one justice once referred to as a suicide pact.
We'll take a break on that note. When we come back, we're going to get into more of those details and take a look at what is maybe on the table as realistic options moving forward with this. And if you have a thought one way or the other, you're welcome to join in the conversation with the professor and I. We're going to take a break and be back with more of our conversation right after this. Stay with us.